NCDRC, National Consumer Disputes Redressal Commission, the apex court of consumer grievances. In a landmark judgment, the NCDRC has yet again strengthened the belief of the common home buyers in the system. But before I come to that specific case, there are a couple of points that need to be answered. Number one, despite several rulings defining the set principles of law, how are builders defining law as per their own convenience? After all, they are fully conscious of the fact that the poor home buyers have limited resources to get into lengthy and costly litigation. Secondly, which is more important, the omissions by the lower courts more often than not emboldens these builders. Why are lower courts at district and state level making mistakes in defining law as it has been prescribed in favor of the home buyers? I am Ravi Sinha, and today I will discuss about this landmark ruling of NCDRC. The NCDRC, in a case against real estate developer Wave Group, has stated that the home buyer is not bound by the period of limitation if there is a clear case of breach of contract. Now, for those who don't understand the legalities and would wonder what is the period of limitation, the period of limitation is the time limit set by the Limitation Act of 1963 for filing a lawsuit, appeal or application. The Limitation Act defines the prescribed period as the time limit calculated in accordance with the provisions of the Act. In this case, the home buyer Veena Jain had booked an apartment in Wave Gardens at Mohali. She was given a provisional allotment letter for a duplex apartment measuring 3275 square feet at a negotiated price of 1,32,63,750. The project was to be delivered in 30 months. And as we all know, there is always a grace period of 6 months. The possession was promised by November 2015, and the home buyer here paid an initial amount of 68,50,836 rupees. However, when she did not get the offer of possession on the promised date, she visited the project site in December 15, and the buyer was shocked to see there was no development at the project site as promised. Yet, look at the audacity of the builder. He demanded a further consideration of 42,28,063 rupees in January 2016. Obviously, since there was breach of contract, promised possession date was not honored, so the home buyer did not pay. So this was followed with another demand note dated July 7, 2018, where builder threatened to levy heavy interest penalty for late payment. Now the buyer clearly sensed foul play on part of the builder. So she demanded her money back along with interest in January 2020. The builder not only ignored her demand, but in July 2020 asked her to take possession after paying all the dues, including the interest penalty of what builder termed as delay penalty. The poor home buyer had no option but to file a complaint before Mohali District Consumer Forum in August 2020, where she complained about deficiency in service and unfair contract. Now, in a blatant violation of the said principles of law, the builder contested her claim, saying that the home buyer is barred by period of limitation. The builder also argued that a home buyer is not entitled to ask for refund after occupancy certificate is obtained and offer of possession is given. The District Commission observed that the last payment was made in September 9, 2014, and the limitation of 2 years would be computed from that date. Since the complaint was filed in August 2020, the Commission dismissed the case as time barred. Jain challenged the order before Punjab State Commission, which surprisingly upheld the judgment of District Commission and dismissed the appeal. The buyer then filed a revision petition before the National Commission, NCDRC, which observed that Section 69 of the Consumer Protection Act 2019 empowers the Commission to condone delay if there is a sufficient ground shown to justify the cause for such a delay. It also noted that a separate application is not mandatory requirement for condonation of delay. The National Commission also noted that the builder had continuously been breaching the obligation imposed by law and contract. It said that the flat was offered for possession after a delay of 4.5 years. And hence the home buyers cannot be expected to wait endlessly for possession. And hence, the NCDRC maintained that the buyer is entitled to claim a refund. The National Consumer Commission also pointed out that there was continuous breach of contract during the period of delay, and hence a fresh period of limitation would run after every moment of time during which the breach continued. Since the buyer had filed the complaint within a month of getting the offer of possession, so NCDRC found the complaint to be in time. Therefore, in its order, the NCDRC set aside the earlier orders and asked the builder to refund the amount with 9% penalty within next 45 days. If not, the NCDRC said that the interest would be 12% if there is any further delay in making the refund. There is no doubt that this judgment is a landmark one. After all, we are talking about a housing market like India, where the home buyers are always at the mercy of the defaulter builders. But the case also leaves some questions unanswered. Question number 1. How could the District and State Consumer Commission aid in making the judgment? Question number 2. Why Section 69 of Consumer Protection Act was ignored by the District and State Commissions? Question number 3. Why builders' delay and defaults are not strictly addressed at the lower courts? The most important question: how many buyers have the might to get into costly and lengthy litigation? The Supreme Court, in its landmark judgment in the infamous Supertech Twin Tower demolition case, had categorically asked as to how many buyers have the might to get into lengthy and costly litigation against the builders. But still, nothing seems to have changed in the Indian housing market. And justice delayed, as they say, justice delayed is justice denied. Will this judgment of NCDRC change the ground realities? Will the lower courts, district and state commissions take it as a precedence and do speedy justice? There are more questions than what can be answered at this point of time. Thanks for watching.